We're indebted to all of you for your excellent evaluations and analysis. I'm struck, Attorney Rivkin, by the fact that you referred to this good cop, bad cop thing, which seems to be common practice. The chairman of the crime committee, Bobby Scott, has listened to police violence and brutality down through the years, long before he became chairman of this part of Judiciary Committee. And I was thinking, you suggested that maybe some of these restrictions on people held at Abu Ghraib and other places may be under more coercion or may have more rights or less harshly treated than what happens in police stations and in the common course around here. And that's very interesting to me because we've been working on that in a number of ways, prosecutorial abuse and police violence, which, by the way, is up, as I recall. And so I hope we get a chance to go into that some more. Now, we have the question of whether a special prosecutor makes a good next step, or whether we should create a FISA-like court, or whether we should try to engage in effective oversight. And Professor Saltzburg, do you have a feeling about what direction we might want to consider moving in when we come back for the last half of the 110th Congress?
I do. Maybe I'll address that in just three specifics. I think Professor Radsan's suggestion, and he does deserve credit for talking early on about the idea of a new court, which basically might be an expansion of a FISA kind of court. And I think it's certainly worth serious consideration, but it is a longer-term solution, I believe. Right now, we have facing you the question of what are we going to do about these tapes that were destroyed, and what kind of an inquiry. Ordinarily, I think the lessons of special prosecutors are not happy ones. And ordinarily, I would say, I have a strong presumption to let the Department of Justice investigate. The problem here, however, is that the department itself has refused to answer questions about whether it was asked about destruction or it advised on destruction. And if, in fact, there's a possibility that it was asked and it did advise, and if it, in fact, authorized in any way the destruction of the tapes, it seems inappropriate to have it investigate itself. And I think this is a big issue. The Washington Post yesterday, 2 days ago actually, had a story which indicated that, and Congressman Scott was talking about this, I have the article right here, that indicated when Judge Mukasey was judge, and the Padilla case, or Padilla, he has now said it both ways, was before him, and he approved a material witness warrant, that some of the information that was obtained and used in the warrant was obtained in the interrogation of Abu Zubaydah. Now that means that Judge Mukasey himself has had a case which may in fact have been tainted in a way by that interrogation, or at least affected. Tainted may be the wrong word. That raises a question just about whether he's the right person right now to be leading this investigation. One thing that the committee is surely going to be aware of is that there's a movement in this country in major police departments, the District of Columbia being one, the American Bar Association supports this, to require the videotaping of all interrogations. And the reason is so that we know exactly what happened. And if there's a challenge to the lawfulness of what happened, we have incontrovertible evidence. If a police department destroyed a videotape of an interrogation in the District of Columbia, you can bet a judge would be saying, why? I want to know why. And I'm not sure I'm going to let a confession in where there's now only testimony and no tape. This committee, I think, needs to exercise its oversight function to answer the questions that you raised, Mr. Chairman, that some of us have suggested, into what it was that those actually were destroyed. Now, Professor Radsan may be right. There may be a whole lot of things that were going on, but most of those things end up being things where the CIA seems to have feared that if that tape ever saw the light of day, that people would see things that they might find profoundly disturbing. As I said earlier, I don't know exactly what the CIA is doing in the secret interrogation facilities. I don't know whether there is one form of waterboarding only, or whether or not the CIA has perfected it and advanced it. I suspect that videotapes would have told us a lot. I just can't resist the one comment about what goes on in police stations and what goes on in secret interrogation facilities. Since 1966, when somebody's interrogated in custody, they're given the Miranda warnings. They're told they have a right to remain silent. They're told they have a right to a lawyer. There's no good cop, bad cop until those people decide they don't want a lawyer and they're willing to talk, and then we have certain rules on top of it. We don't give Miranda warnings, and I don't think we should, to people who were detained for intelligence interrogations. But to compare the two and say we are tougher on people who are arrested and charged with crime in the United States than we are on terrorists is ridiculous. It ignores what goes on daily in every police station in the United States where police officers conform to the law. So basically, I think you make a good case, given the peculiar circumstances that we face now, that there should be a special prosecutor. I think that some consideration given to a court that has expertise in intelligence matters that would canvass more than just interrogation, including surveillance and the like, would make a lot of sense. But that this committee and this has an obligation to investigate and not wait for a new court.
Thank you. Professor Radsan.
Mr. Chairman, when I was a student, I didn't like when professors answered my questions with a double negative, but I'm going to do that here. I'm not opposed to a special prosecutor for the reasons that you've highlighted. The Justice Department was actively involved in giving guidance on the detention and interrogation program. We're going to find out whether the Justice Department was involved in any way in advising about the destruction of the tapes. We know that there are at least one case, the Padilla case, that may have been influenced by something that went on in one of those interrogations. It's going to cloud some of the existing criminal cases that the Department of Justice has. I know that people were concerned about the Attorney General's reticence about waterboarding, that if I were in the department and you asked me, I think it is a cleaner way to get to the bottom of what happened with the tapes. To alarm the committee a bit more, it's only a few weeks ago that the New York Times reported that Director of the CIA, Michael Hayden, had set up an internal unit to inspect the Inspector General. That we didn't trust our internal affairs, we had another internal affairs. The reporting has been that this is a joint investigation into the tapes between the Justice Department and the Inspector General. That complication, the complication between the Inspector General, the General Counsel, the Inspector General, and the Director may be another reason suggesting that we should have a special prosecutor on the tape.
Thank you very much. Attorney Rivkin.
Thank you, Mr. Chairman. On the question of special counsel, these are, in many respects, the kind of institutional issues that I don't think that the two branches would ever see eye to eye across the board. But let me just point a couple of things, and let me quote the Washington Post editorial from a couple of days ago. We do have a new Attorney General, a man of exceptional probity. I've not had anybody challenge that, who has said very clearly that we have normal investigatory procedures by the career people in the department involving career attorneys from both the national security divisions and public integrity section. In some sense, when somebody says that per se this is inadequate, we're impugning the integrity of people who spend their lives in the government, who are not partisan, who are looking presumably at the facts as they are. If at some point in time information comes to light that suggests there's a real conflict here, I have no doubt that the Attorney General would reach a decision to appoint a special counsel, not an independent counsel, not to be pedantic, there are no more independent counsels, but a special counsel in accordance with Department of Justice regulations. But the notion that it should be just done at the outset without going through a normal process, it seems to me somewhat unfair.
You don't see any existing conflict?
Not on the facts. Let's assume, for example, and this is, and I hate to speculate, but these are the speculations of the media. Let's assume that, I know it's not an assumption that everybody in this room would share, that while the destruction of a tapes may have been foolhardy, or their creation may not have been wise, because, all due respect to my colleagues, the normal procedure in the FBI and the police department right now is not, repeat, not, to create videotapes. I think the decision to destroy them would have been foolhardy. Whatever it's worth, if it was up to me, I wouldn't have done it. But let's assume it's a policy question. You have a whole bunch of lawyers, including the White House counsel's office and the Justice Department, who said, our advice to you is not to do it. But because we're modest lawyers, we're not trying to play, policy-making role here, because there's no legal bar. Our advice as a prudential matter, don't do it, but otherwise it's up to you. If that's that kind of situation, I don't see any conflict here. And in fact, nobody has suggested in any of the stories in the media so far, but they're trying to encourage them to do so. I mean, every single person, including some of those, I'm sure you'd have policy difficulties, including David Addington and Harriet Myers, urged them reportedly not to destroy them. So where's the conflict for the lawyers involved? If it appears to be a problem, I'm sure that the Attorney General would do that. But let me take 30 seconds and make the point, which I think, frankly, is far more important on how this investigation will proceed. I'm not advocating rough techniques in police stations. All I'm saying to you is this, that the particular parameters for the good cop, bad cop routine outlined in the Army Field Manual, with all due respect, are far more restrained than non-abusive, lawful interrogation techniques. For example, you're not supposed to threaten somebody. Let's think about what it means. Then the police interrogators or investigators are going to interrogate, a fellow by the name of Faustow, who is one of the key players in Enron, and tell him that if he doesn't cooperate, they're going to nail his wife and put her in prison. If it's not a threat, if it's not a coercion, I don't know what coercion is. And that technique is available to you in the context of a normal criminal investigation. And yet, under the plain language of a manual, it doesn't appear to be available to an interrogator, because you cannot use intimidation of any kind. We should have at least an honest, mature discussion why we cannot have a baseline across the board in public sphere as to what level of coercion is appropriate, instead of only talking about it in this context, because I cannot imagine why we should be treating Andy Faustow, who I'm not holding any candle for, who undoubtedly is a bad guy and a criminal, why should we be treating him better than Abu Zubaydah? That makes no sense to me.
We should also notify the producers of television cop shows that they ought to use a little bit more legal restraint in the course of their activities, because the idea that it's okay, because you see it every night. Ms. Massimo, help us out here.
I have a couple of points I'd like to make on this. One is, Mr. Rivkin referred early on to the importance of the question of the legality of the underlying conduct even being more important than the tapes. And I think that is where the conflict arises, which leads to a requirement of having a special counsel here, because we're talking about questions about whether or not techniques that are depicted, captured on those videotapes are unlawful. That relates to the question of whether or not the destruction of the tapes would be the obstruction of investigation into criminal activity. So I think that's really where for me, the strongest argument is that you need to have that. I do need to take issue with one thing that my friend to my right said, and that is that I wouldn't want this committee to get the impression that what we're talking about here when we're discussing interrogation techniques is whether or not interrogators can yell at a prisoner or be mean. The enhanced techniques that we're talking about and that we outline in this report, Leave No Marks, these are serious forms of torture and cruel, inhuman, and degrading treatment. Long time standing, this is another euphemism for stress positions that the United States has prosecuted as a war crime. waterboarding, forced hypothermia, forced nakedness, the use of dogs. These are techniques that have been reported to have been used under this enhanced interrogation program. We're not talking here about whether or not, you can yell at a prisoner or make them uncomfortable.
Thank you so much. If you want to put your document into the record, we'll accept it at this
Thank you,
point.
sir, very much. I'd like to do that.
I'd like now to turn to the chairman of the Constitution Committee, Jerry Nadler.